Hello. Before we start, I should mention that what we are going to discuss today are rather general rules and principles, and there are exceptions. So if you have your particular case, your particular situation, as always, I strongly encourage you to consult your own lawyer with all the facts. And having said that, let's get to the general approach. We're talking today about damages. Well, technically, we're talking about civil responsibility, but as I will try to show later on, the issue of damages is like the crucial issue for civil responsibility. Many people mix up criminal, penal, and civil responsibility situations. But for us, what's important is that who is pursuing. When it comes to criminal and often penal, it's the government, because whatever is the wrongdoing, it's considered to be done against the government, against the society, against public order, and therefore, basically, whoever reported that to the proper authority might think that their job is done, and now it's for the government to pursue. Civil responsibility, again, but for certain nuances and exceptions, it's a case between two private persons. It might be that the government is involved, but counterintuitively in such a litigation, the government, for example, as an owner of some building, would be involved as a private person, not as the government. And there, to pursue somebody in civil responsibility, one should have so-called standing, meaning like, what's your business? It's not everyone's business. You have to be somehow involved. You have to be somehow personally concerned and touched by the situation, by what's happening. And again, as opposed to criminal and penal, usually seeing that somebody is at fault, somebody has done something wrong, it's not enough to initiate civil responsibility. And before we get further to that, there is one more caveat. Because as not even opposed, but like parallel to civil responsibility, there is a contractual responsibility. So often, if somebody does something wrong, but you're in against you, but you're in contractual relationship with that person, and if that wrongdoing is somehow covered by the contract itself, then civil responsibility is not available anymore because you have a regime of contractual responsibility. Sometimes it might be in parallel. There might be a part in contractual, part in civil responsibility. Again, if you already appreciate that it's complicated, if you have your own case, consult your own lawyer. As you may know, to have a case in civil responsibility, three things, at least in Quebec, should be presented to the court, should be proved. One is fault. But again, there are no fault regimes. One of the exceptions. In certain situations, for example, when some damage was caused to somebody's body, so it's like bodily injury, there might be a situation of no fault, or there might be a statutory responsibility saying that for this specific kind of situation, again, consult your lawyer for specifics, the responsibility comes even if there is no fault, which also counterintuitive to many, because we have a tendency, especially those who watch some like TV series about lawyers, to think that, first of all, there should be a proof of fault and there should be presumption of innocence. But in civil responsibility situation, there might be a no fault responsibility, and there is no presumption of innocence, by the way. There is another thing called the proof on the basis of balance of probabilities, but it's not the same thing. So normally, first of all, a person should be at fault. And in most of situations, if there is no proven fault, then there is no further case of civil responsibility. And sometimes fault is simply proven by the fact that the person was negligent, that the person didn't do what a reasonable person, reasonably diligent person in circumstances would do. Sometimes there are specific requirements, like in some, for example, code of ethics, deontology codes, or other professional codes, which are not technically laws, sometimes not even regulations under a law, but still the courts usually recognize that if there is a breach of such a duty of loyalty, duty of care, so forth, it might be seen as fault. Second thing is that this fault, whatever it is, should directly cause the damage. Meaning that if the person is like a bad person, and you can prove that generally just he's kicking dogs, like hitting somebody's cars, shout swear words in church, whatever. So there are a lot of faults, theoretically, but none of them directly, that's important. Not under somebody's impression, not through some like step-by-step process, but directly caused the damage. So there is no direct causal link. Then again, the case in civil responsibility will most probably not go. But as I mentioned at the beginning, the most important part is damage. But for certain, again, exceptions, the general principle might be formulated this way: no damage, no responsibility. Because somebody might be at fault, might be doing something like otherwise would be really reprehensible, and you didn't like it, but there is no proven measurable damage. Monetary damage, bodily damage, moral, again, proven by a doctor or social worker, or them both, damage. You simply didn't like it. Maybe you didn't like it a lot. Maybe it actually insulted your best feelings, for example. But if there is no objectively measured and proven damage to your body, to your finances, to your reputation, to your dignity, to your privacy, but again, measured and proven, not only just how come it's not damage. Asking questions is not evidence, it's not proof in court. You should bring your own answers and proven with documents, at least with some expert report. No damage, even if there is fault, no responsibility. So basically, somebody might be at fault and still not responsible if there is no measurable damage. Therefore, even though the sequence is usually presented as fault, causality, damage, or injury, if you want to prepare to build your case for the court, you should have started in inverse order. First of all, can you prove damage? Then, can you show that it's directly linked to somebody's action or inaction? And only then that action or inaction was a faulty one, was wrongdoing. Why it's important? Because often, at least those who come to a lawyer, to us as to consult about possible civil responsibility, they start with wrongdoings. They are outraged. They think that somebody did a lot of wrong things, and they think that there might be a case in court, and they're very much disappointed that, well, upon reviewing proof and documents, it seems that the case is not strong enough to go to court for this particular reason. It's usually relatively easy to show wrongdoing, to show fault. The real pivotal point is to show damage, to prove damage. Not only to say that there was damage, even out loud, even emotionally that it was damage, but to prove that there was some measurable damage. If there is none, there is most probably no civil responsibility. There are nuances, there are caveats, there are exceptions. Consult your lawyer. Thank you, and have a nice day.